So, welcome to episode number 1 of Know Your Rights. And today we're going to be talking about the Miranda rights, as you can see in the title below. So, the first question is, what are they? Anyone who's ever seen any sort of crime movie or TV show probably knows that at the end when they catch the bad guy, they always read, you have a right to remain silent, you have a right to an attorney, and screen fades to black and the credits roll, right? But it's a lot more than that, and what they don't show is pretty important. So let's just get right into it. The Miranda rights are the rights that you have when under police custodial interrogation, which means you've been arrested and they're asking you questions about the events that have occurred or the crimes that you've been accused of, basically. So the case that most people know is called Miranda v. Arizona, which is kind of the case where the Miranda rights get their name from. But in reality, the Supreme Court ruled on 4 separate cases. So obviously you have Miranda v. Arizona. You've also got Vignera v. New York. You've got Westover v. United States. And you've got it's called Stewart v. California. And so the common theme between these 4 court cases were that all 4 of these men were never informed of their right to remain silent or have counsel present at the time of their interrogation. And as a result of the information that was gathered during their interrogations, they were sentenced and convicted for the crimes they were accused of. The only difference between these 4 is that in California v. Stewart, it was the California Supreme Court that overturned this conviction before reaching the Supreme Court. And so the central question of the Supreme Court case is, can information taken from the accused during a police custodial interrogation be used in a trial? And is it necessary, and does the burden weigh on the government to ensure that necessary steps are taken to protect their rights to counsel during these times? And so the Arizona v. Miranda was argued before the Supreme Court in February and March of 1966, and it was decided on June 13th of 1966. So they voted 5-4 in favor of the idea that the Fifth Amendment rights exist outside of court proceedings, which means, outside of the trial, and it extends into, pre-trial and whatnot, basically in situations where there are more compelling circumstances to pressure a subject into self-incrimination, which begs the question, what is self-incrimination? Self-incrimination is, in essence, any action that one would take and anything that one would say which would implicate oneself in a crime. And so clearly in the Fifth Amendment of the United States Constitution, in the Bill of Rights, there exists a definite protection against self-incrimination, which means that you can't be punished for refusing to incriminate oneself in one of these custodial interrogations or pretrial proceedings, whatever. So basically it says that the police and prosecution cannot use statements that were required in custodial interrogation without safeguards to secure the privilege of protection against self-incrimination. So basically, the Supreme Court laid down these laws, commonly known as the Miranda rights or the Miranda warning. And it differs on how they say it between precincts and states and cities and whatnot, but the essence of the message is the same. You have to let the suspect know that they have a right to remain silent. Anything they say can be used against them in a court of law. They have a right to an attorney during this interrogation, and if they cannot afford an attorney, or if they're, in the words of the court, indigent, then one will be provided for them at the expense of the state. So there are some stipulations with the Miranda rights. There are some conditions which surround it and its use. So it only applies when the suspect is in custodial interrogation. It means they have been detained and arrested by the police and they cannot leave. If they're arrested and they're being interrogated in that situation, then yes, they must be read their Miranda rights. However, if one is not in custody, there is no burden on the police officer to inform them of their Miranda rights. So if a man was standing on the sidewalk and a police officer came up to him and explicitly told him, "You are not being detained and you are free to go at any time," and the man volunteered information which would implicate him in a crime, that information and that evidence is admissible in court because technically he was not under any kind of duress, any kind of interrogation, or in any situation where there would be pressure for self-incrimination. he voluntarily gave up that information. And so there are definite exceptions to the Miranda rule, like all rules. So the first one of the three which I found most pertinent are standard booking questions. So this is basically when a suspect is being brought into the station and being processed for jail. So the Supreme Court basically holds that this exists outside of the protections of the Miranda rights. So it's basically just biographical information like a suspect's name, address, date of birth, things you need to properly process an inmate. And so the second exception is the emergency exception, which applies when officers are responding to a potential emergency. So there are three categories of requirements that must be met for this to apply. So the officers must believe that there's a reasonable basis that their immediate help is needed in this scenario, like someone or someone's property is in immediate danger. The police officer must not be secretly motivated to arrest someone and seize evidence, and there must be reason to believe that an emergency condition exists nearby. And so the court case which decided this was it was in New York, and a police officer arrives on the scene and he found of a suspected murder. Someone had called 911, someone had been attacked, and so he shows up and there's a man covered in blood, and he asks for a ride back to his van, and when the police officer takes him back, he asks him questions which leads to finding the body of this man. And so because of the blood, because of the impending murder call and whatnot, this was ruled to be a case of the emergency exception, where the police officer did believe that there was someone in immediate danger. And so the necessary requirements of allowing this alleged murderer to know his Miranda rights was waived. So which meant that even though he said that he wanted a lawyer, they continued to question him, and they had the right to do so. And the final major exception to the rule is called the jailhouse informant exception. So the Miranda right applies when government agents, such as police officers, are interrogating someone in custody. That's been established. What it doesn't cover is the fact that the government does pay people and incentivize basically informing on fellow prisoners. And so it's led to cases where jailhouse informants sharing cells and whatnot with the accused. A lot of times people waiting an upcoming trial, they have collected information and confessions basically, and it has been admissible in court. The only stipulation is that these informants cannot elicit a response. They can't chase a response. They can't try and prod and poke and make it so that they push the accused towards giving them information they wouldn't otherwise give. So they may only passively collect information that's freely given. So the Supreme Court ruled that in undercover operations, such as this, the right to avoid self-incrimination still exists, and the rights of the Miranda warning still apply. And so, finally, the most important thing to take away from all this is if someone finds themselves in a situation where they believe their Miranda rights have been violated, the most important thing to do is to contact an attorney immediately and say nothing else. And so, building off of that, if someone is approached by a police officer and not detained or anything like that, they're told they're free to go, they haven't been explicitly arrested, the best thing to do is to say nothing or just walk away, because you can do that. And if one has been arrested, then the best thing to do is explicitly state that that one is exercising their Miranda rights, and say nothing until an attorney arrives. So, this has been episode 1 of Know Your Rights. I hope everyone found it informative and interesting, and I hope you come back and watch episode 2.